Good evening and a warm welcome to everyone. Thank you for attending this seminar hosted by the Palestine Solidarity Association of Sweden, Palestinagrupperna i Sverige. We are happy to see so many people joining. The title for this evening is Justice for Palestine, a Question of Law. My name is Anna Wester, and I will, together with Per Schitt, act as a moderator. And now I will hand over to Per, and who will tell us about any technicalities regarding the Zoom program and also introduce this evening's speakers. So welcome, everyone.
Thank you, Anna. My name is Per Schitt. I'm also part of the Palestine Solidarity Association of Sweden. Before we welcome the first speaker of this evening, I will just tell you a little about the organization Palestine Solidarity Association of Sweden. And Anna is now sharing a screen with some pictures and web page information. This is non-partisan and non-religious Swedish NGO that was established in 1976. And through advocacy, spreading of information, activist campaigns, etc., PGS is demanding an end to the Israeli occupation of Palestine with a just peace settlement. All PGS activities are firmly grounded in human rights, UN resolutions, international law, and the Sustainable Development Goals. Our backbone is our 17 local groups found all over Sweden. Current projects include, for instance, and these you can read about more on our website. They include a campaign regarding the sports brand Puma, an ECCP campaign focusing on the ongoing international trade with goods and services from illegal Israeli settlements on occupied ground. And we also just recently produced our latest issue of our annual theme magazine with Swedish schools as our main recipient. And I'd like to point out that we have a very good outreach to schools in Sweden. PGS is also the initiator of a so-called PCO program with local projects within organizations in Palestine and Lebanon, the latter where there are many Palestinian refugee camps. These projects focus on specifically hands-on things to do with young people and their situation. For any more information, please visit our websites. And as you can see, we also have 3 channels for social media. Okay, so now for the main section of this evening, I would like to introduce our first speaker. His name is Henrik Carlborg, and that's not a new name to the PGS, but only since a couple of months ago, he was elected chairperson at our biannual Congress. Henrik has a huge historic knowledge of the Israel and Palestine question. He speaks Arabic fluently, and he's also a lawyer. And with that, I'd like to hand over the microphone to Henrik, the first speaker of this evening.
Thank you very much, Per Schitt. Okay, so this webinar, in this webinar, we will be talking about public international law and the role that public international law plays in the conflict between Israel and Palestine. And of course, there's so much to be said about international law and the Middle East in general, and Palestine in particular. And of course, Alice will get into some of the details later. First, I would like to take a step back and ask a more basic question. Why international law in the first place? Isn't there some other standard, perhaps some other criteria we could use for how to devise a good solution to the conflict at hand? Some people find law impractical, and maybe they think there should be something more flexible, something that gives us more different opportunities. Well, the short answer is no, there is no alternative to international law. There will be no stable or lasting peace unless it is based on law, and there can certainly be no just peace, unless, of course, it is based on law. And I shall now explain what I mean in greater detail. A friend of mine asked me a while ago, he asked me a question a while ago. He said that there were many refugees in World War II. In fact, there were large territories in Europe, for example, which were all but cleansed of their populations, a bit like Palestine, he said. However, after World War II, he said, these refugees simply settled peacefully in whatever countries they ended up. And there was no continued territorial conflict, no right to return, no demands for compensation, and so forth. And he asked me, can't the Palestinians simply do the same, just well, give up, basically? My response to him is, firstly, of course, that the World War II is one of the most horrifying episodes of human history. And there was the Holocaust, as you well know. 6 million Jews were murdered. There were 30 million dead Russians, and still counting. Atomic bombs were used for the first and last time, we may hope, and there were wars of aggression, there was annexation of other countries' territories, etc., and so forth. So World War II does not exactly set an acceptable standard for what is right and wrong. Besides, after World War II, things changed. The UN Charter, the Universal Declaration of Human Rights, the Geneva Conventions, 4 of them in 1949, the Genocide Convention, all these laws were made. Public international law went through an overhaul. And as Alice will explain later, you might say that modern international law, as we know it, was born in the aftermath of World War II. Certainly, when we talk about human rights law and humanitarian law, certainly the post-World War II period is saw a new era in international law. The idea was, of course, that the terrible things that happened during World War II should never be repeated. In other words, what might have seemed acceptable to some during World War II and earlier should no longer be acceptable in the future. Of course, the upshot of it all is that the might is right idea that sort of prevailed pre-World War II and during World War II to some extent is certainly not an acceptable way of dealing in international affairs. Some people have other ideas of what should be right or wrong. Especially in the Middle East, some people cite religious sources in order to support this or that political position. This can never lead to an acceptable solution, and there are several reasons why it cannot. The Bible and the Holy Quran were written in a different time, a different place, and for purposes other than solving political disputes, perhaps 1,000 years later. It is quite difficult to find an answer in the Bible to modern problems of political disputes. And I would say it's impossible to find one that is acceptable to all parties. A very important point here is that there's no agreement on which religious sources should be applied to the conflict and what interpretation of these sources. Such agreement is, of course, highly unlikely. Jews would not accept the Quran as a basis for how to solve the conflict, and Muslims would not accept Jewish religious sources for how to solve the conflict. In some ways, I guess you might say that religion is the very opposite of international law in this regard, where religious interpretations are unilaterally applied by one side and imposed sometimes by force on the other side. International law, by contrast, consists of rules agreed upon by the parties. Agreed upon by the parties, that's a very, very important point. Israel and Palestine have indeed signed and ratified relevant conventions and treaties. And in so doing, they have agreed that these are the standards, these are the rules that should be applied. And another difference is that where religious sources needs some sort of rather far-fetched interpretation in order to be used in a modern context. International law is specifically designed to apply to concrete situations. And Alice will talk at length about some of these rules, some of these sources that apply to this conflict. Of course, some people say, quite often, in fact, that negotiation is the only way to solve the conflict between Israel and Palestine. Well, to an extent, that is true. A negotiated solution should, however, never stray too far from the standards of international law. And if it does stray from international law, a bit here, a bit there, then both sides need to concede rights in equal measure. If, by contrast, only one side does all the conceding and the other side all the gains, then we're not really talking about a solution to the conflict. What we're talking about in this scenario is might makes right, but disguised as a peace treaty. And such a solution simply discards international law. It creates hatred and frustration on the losing side and will only lead to further conflict. Which brings us to an important assumption of this seminar, this webinar. Where international law is applied, there is peace. Where international law is not applied, there is no peace. And the Middle East is, of course, clear proof of this. Ever since the beginning of the 20th century, there has been conflicts in the Middle East. And all through this period, international law has been disregarded. In the words of one legal scholar, public international law in the Middle East is applied and interpreted selectively and coercively, used coercively, and in noticeable situations, simply disregarded. In other words, law is in fact the answer to a great extent. There is no alternative to international law to find a just solution, a lasting solution to this conflict. There will be no stable or lasting peace unless it is based on law, and there can certainly not be any just peace unless it is based on law. And thank you very much. And now back to Per and Alice.
Thank you so much, Henrik. Okay, so I'd like to tell you that in 2017, PGS was one of the organizations that was hosting and contributing to a speaking tour in Sweden called Focal Point E1. We had an international delegation with, for instance, activist political expert Angela Godfrey-Goldstein from Jerusalem, Eid Abu Khamis, spokesperson for Khan al-Ahmar, just outside Jerusalem, plus, at least for me, new name, Dr. Alice Panepinto, who made a huge impression on everyone with brilliant presentations and very important presentations. We visited schools, activist groups, and also the Ministry of Foreign Affairs, plus the Parliamentary Committee of Foreign Affairs. Alice lives in Manchester and is also a lecturer at the Queen's University of Belfast. And just a few things I pick up from her presentation on the university website says, Alice researches international law, human rights, and transitional justice with a regional interest in the Middle East. Starting this year and going up until up through 2022, I think, she will be leading a project that seeks to better understand the humanitarian impact of continued forcible transfer of Palestinian Bedouin communities living in E1, Jerusalem, and how impunity for violations of international law contributes to the deterioration of humanitarian vulnerabilities. And I'm also informed that this project is done in collaboration with the Al-Quds University in Jerusalem. So, Dr. Panepinto, we are so happy and honored to have you doing this webinar. And I know that we're all going to learn many important and interesting things today. A big welcome to you. And now the stage is yours.
Thank you very much, Per-Anders, for your kind words and your introduction. And let me extend my thanks to all of you for your kind invitation. It's wonderful to join our, well, my Swedish friends who are working tirelessly for issues that are very close to my heart. So it's wonderful to be back, albeit virtually. I know that time is of essence, so I will share my screen. Hopefully, you will all be able to see it in a couple of seconds. Yes. I can see it. Can everyone else see it? Yes, thank you.
Yes.
Thank you for confirming. So just building on what Henrik already outlined, the question of justice for Palestine is a question which necessarily goes through a question of international law and a series of questions about international law, its aims, purposes, but also its limitations and the way that it can be used or not used for a range of, let's say, positive or less constructive reasons. I am a firm believer that there's a lot of power for good in international law, but we also must look at it for what it is. So hopefully in the next half hour or so, we'll be able to touch upon some of these themes in relation to Palestine, and I look forward to everyone's questions at the end. So I will offer a whistle-stop tour of how international law in Palestine might operate. And 1945, the establishment of the United Nations from the ashes and horrors of World War II is the landmark. Before that, the world looked very different under international law. After the establishment of the United Nations and all the international treaties that came about from that organization's inception, sets out the international legal standard to which we aspire. Now, of course, that standard has not been met, but we can look at this in more detail later. I will then touch upon the Palestinian Bedouin community facing displacement. As Per-Anders already mentioned, I am currently working on a 2-year project funded by the Arts and Humanities Research Council and the newly formed FCDO, which is the Foreign Office in the UK and the former DFID. And then I will talk a little bit about the possibilities and limitations of the ICC and the ICJ, both of which currently are considering Palestine, albeit slowly and with little result so far, but still an opportunity is there. So just so we're clear about this, and this goes to something that Henrik already alluded to, why international law? What else? Of course, we cannot take law and international law in particular out of context. There are political considerations and there are morality considerations. And when we talk about justice for Palestine, the 3 elements coexist. There are synergies and there are tensions. And thinking a little bit about some of you in the audience who might be involved in advocacy work, civil society, grassroots, human rights defender work, why should Palestine activists care about international law? Well, you of course need to have the factual accuracy from the ground up, and that is interpreted very often through the lens of international law. Historical awareness, the ups and downs of international law are accompanied by history, and history is accompanied by international law. The legal framework offers some parameters, which are both aspirational ideals, but they also offer some practical tools, not always particularly effective, but they do offer possibilities that other areas such as politics alone or morality as an abstract ideal might not offer. International law also helps us with our critical thinking. It offers solutions, but it also outlines new problem areas. And international law is not perfect. We all know this. The more you work in international law, the more you realize this. So I think international law can help all of us be more effective advocates of justice for Palestine, but also better effective activists for peace and justice for everywhere, everyone, whoever you are, wherever you were born. So very importantly, we must be mindful of the limitations of international law and the human rights project that sits within the parameters of international law. As activists who operate in solidarity, we must be mindful of how we use international law and human rights language. There are very problematic aspects that we must be mindful of. So Professor Muta, for example, talks about the difficulties of talking about, victims and saviors. So let's think about our role very critically as well. There's a problem, for example, when it comes to the root causes of human rights. If we look at international law and human rights, we quickly realize that there are areas of the human experience that fall beyond the pale. So the question is, has international law and do human rights leave some gaps? The short answer is, unfortunately, yes. So what can we do to make sure that those gaps are reduced? And of course, there are colonial legacies to international law that cannot be overlooked. And a fellow Nordic scholar has written about this in various books and articles. So for those of you who are interested in the scholarly approach, that could also be an interesting reflection. So mindful of the limits of international law and human rights project, while we advocate for justice through the international law and human rights parameters. The ambiguous relationship between international law and justice for Palestine is well documented. We know that the UN has been a friend to Palestine and to Palestinians, but it has also been an enemy in many contexts. You can read more about this ambiguous relationship and the tensions there in many sources. I've just indicated 3 sources which have shaped my way of thinking most recently. So with those premises, we can move on to a whistle-stop international law timeline for Palestine. I've included here a picture I found on the internet of the train from Jerusalem to Jaffa as an example of the extremely high level of human and economic and cultural development of Palestine prior to the Nakba. So, as we've already said, 1945 changes the rules of the game. Before 1945, a number of things happened which were acceptable at the time. So I'm referring to the Sykes-Picot Agreement, the Balfour Declaration, the very concept of British colonialism in Palestine, and disposing of territory and people as if they meant nothing. All of that was occurring in a context where it was wrong for political and moral reasons, but the international legal framework was not there yet. With the UN Charter in 1945, the international legal order, which is in force today, comes into being. And we should think about that moment as the moment. Moving on from June 1945, that is where we hold states who are part of the international community, who have signed and ratified the UN Charter, which is a treaty. Nobody forces any state to join the UN Charter. We expect those principles and those norms to be respected. After 1945, however, the story of Palestine and international law becomes even more complicated. So The UN establishes a special committee to study the problem of Palestine, and it discusses two options: partition or a binational state, rightly and firmly rejected by Palestinians. But the latter option, partition, is embraced by the Zionist movement. We then have some very difficult years for Palestine and the Palestinians that, as we all know, progress sadly towards the moment of partition. So we've spoken about the importance of 1945 already. Before that, Middle Eastern politics was a colonial game. Arguably, Middle Eastern politics never really stopped being a colonial game, but the standards to which we expect international actors to operate at are different because of the UN Charter. So in the middle of World War I, a secret convention between the French and the British, with the Russians participating, meant that in Europe, a group of people were talking about how to carve up the Ottoman Empire without really asking the people in the Ottoman Empire, including in Palestine, what they wanted to be. Colonialism 101. The Holy Land fell under the shared control of Britain and France, as you know, but Britain was not very happy about that. Britain had very important commercial reasons to have access, unimpeded access, and access not shared with others to the great ports of Palestine. I'm talking of Jaffa and Haifa as well. So the Balfour Declaration is to be understood in the context of British colonial and commercial aspirations towards the end of World War I. Again, we do not see any efforts made to actively and meaningfully engage Palestinians in this conversation, as we know. Balfour the man was far from an inspiration. He was a man of his time. He was a man who had a problem with immigrants. And it was his problem with immigrants that in many ways inspired him to think about what to do with a minority population within Britain. You can read more about Balfour the man in Shlomo Sand's book, The Invention of the Land of Israel. This is a man who didn't think twice about closing the borders when the country could have welcomed refugees fleeing the pogroms of Eastern Europe. So let's remember that we're not talking about a visionary. So again, 1945, New World Order. As Henrik mentioned, the international community at the time, which of course excluded all the colonial territories that did not enjoy full sovereignty at the time, all the people who were not sitting at the table at that time were excluded. But those who were there were thinking about the never again. So the Charter is premised on peace, human rights, and justice for nations large and small. But of course, the document is a product of its time. It talks about peace, good neighbours, maintaining international peace and security, and of course it limits the use of armed force, as you know. The article of the UN Charter that I would like to take as the benchmark for the rest of the presentation this evening is Article 2.4. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the UN. So what does Article 2.4 tell us? So from 1945 onwards, there is a ban on military conquest. This ban on military conquest is based both on the actual use of force and on the threat of the use of force. So we don't necessarily need to have tanks and boots on the ground. It's the threat that I would like to focus on, and please keep that at the front of your mind. So 1945, the ban on military conquest. But what about Palestine? We know that in November 1947, in resolution 181, the situation in Palestine was identified as one that would cause concern. It was decided that the mandatory power, that is Britain, would evacuate the Holy Land, as you all know, and the partition would have come into being. As you see, the voting pattern, which I include in the right-hand side of the slide, includes a number of countries for, a number against, and a handful abstaining. Amongst the countries for, you will see a green arrow indicating Sweden was a country that also voted in favour of partition of Palestine. We all know what the partition plan was meant to look like. Again, this plan was firmly rejected by the Palestinians, but nonetheless, this became the UN position, which is problematic for all the reasons we've seen already. Of course, in reality, the partition plan was not what happened. The Nakba was even more horrific for Palestinians, and the catastrophe of the mass expulsion of Palestine, of Palestinians from Palestine at the time of Israel's creation, is something which is carried in the hearts of all Palestinians many generations later, even if they're part of the diaspora, even if they've never set foot in Palestine. We have plenty of historical sources on the Nakba, and if you're interested in finding out more, there are both Palestinian scholars and Israeli scholars who provide detailed accounts of what happened at that time. We know that there are nearly 1 million Palestinians expelled or made refugees, and as of 2009, these are sources. This is a source that I found on the website of the Institute for Middle Eastern Understanding. There are over 7 million Palestinian refugees and displaced persons, many survivors, many descendants. Since the Nakba, international law has remained an ambiguous and yet important tool of justice for Palestine and for Palestinians. Two core rights, the right of return and the right to self-determination, are have been taken together as part of the joint struggle for justice in Palestine and justice for Palestinians. I'm sure you're all aware of the political dimensions of the right of return and of self-determination, but just to give you a sense of the right of return's foundation in international human rights law and significance in international criminal law as well, the right of return is enshrined in the International Bill of Rights, the Universal Declaration of Human Rights, the most important human rights document emanating from the United Nations. Article 13 reads that everyone has the right to leave any country and to return to his country. You'll excuse the 1948 sexist language of his as opposed to his and hers or their. but this is important. The right of return is included in the Universal Declaration. But what happens when the right of return is not allowed, when it is denied? Right, so fast forward from 1948, when it's enshrined in the Universal Declaration, to 2018, in the recent proceedings before the ICC on the Rohingya Myanmar case. Pre-trial Chamber 1 of the ICC found that denying the right of return is a crime against humanity. And this is in addition to deportation and forcible transfer. This means that as of 2 years ago, we also have clarity and confirmation as to the importance of the right of return, not just based on the abstract principles of the Universal Declaration of Human Rights, but there are serious implications here too. The right of return of the Palestinian people is something that has been a feature of Justice for Palestine since 48 onwards. So we know in the General Assembly Resolution 194 of 1948, the day after the adoption of the Universal Declaration, we have a document that reads, refugees wishing to return to their homes and live at peace should be permitted to do so at the earliest possible opportunity. And for those who choose not to return, they should be compensated for the loss of property or damage to property. So this is 1948, a day after we have the Universal Declaration stating the right of return as a cornerstone of international human rights law. We also have the import of this principle in conversations at the UN about justice to Palestine. And it continues. Following the Six-Day War in 1967, Security Council resolution calls upon the government of Israel to facilitate the return of those inhabitants who have fled the area since the outbreak of hostilities. And again, in 2019, the Commission of Inquiry on Israel's attack against Palestinians in Gaza, seeking to exercise the right of return, recalls that the right of return is a central feature in that context as well. So from 1948 onwards, there is plenty of international law that in principle supports the right of return of the Palestinian people. In practice, there hasn't been much done to implement that norm, but it is there. The black letter of the law is clear. There is very little scope for disagreement on what the international law parameters on the right of return for the Palestinian people are. Just to add an additional lens to the importance of the right of return in the context of apartheid, the Apartheid Convention of 1974 also states that the right to leave and to return to one's country is a fundamental feature of human rights in the context of apartheid. I won't go into the right to self-determination in Palestine in detail. There is plenty written about this already. Suffice it to say that it is included in Article 1 of the UN Charter, again from 1945 onwards. The right to self-determination is featured prominently in the international legal order to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. This, of course, is in the context of colonialism and decolonization. And of course, the Palestinian people were a colonized people by the British until, of course, things changed and the state of Israel was proclaimed and the situation was complicated further. But we can still invoke Article 1 of the UN Charter because it is a fundamental principle of the international legal order today. And of course, there is absolutely nothing in international law that says that the Palestinian people do not have the right to self-determination. For those of you who are interested in self-determination and Palestine in an interdisciplinary context, I highly recommend Edward Said's seminal text that I include in the slide. Let us fast forward now to the Six-Day War and occupation from 1967 onwards. Now, I won't go into the detail of international humanitarian law, which is the branch of international law that tends to be a bit more technical. We'll refer to it as little as possible, but it is central to justice in Palestine as well. Under international law, occupation does not transfer sovereignty. There is not an atom of sovereignty in occupation. In international law, occupation is meant to be temporary. That is a beginning and a clear end. Under the Hague Regulations and the Geneva Conventions, the occupying power has various responsibilities. It does not have various rights. There are a number of fundamental principles of international humanitarian law, such as the principle of distinction between combatants and non-combatants, the principle of proportionality. So actions must be proportionate, as well as being militarily necessary. But at all times, it is important to remember that there is a distinction between civilians and combatants. What we saw, sadly, from 1967 onwards, which is a stain on the conscience of international law as well as the UN, has been the unilateral annexation of Jerusalem. A painful moment, I think, for many. From 1967 onwards, the occupation of Jerusalem did not cease, and instead it entrenched, to the point that in 1980, Israel unilaterally annexed East Jerusalem, including the Old City, in a basic law, which has constitutional status. It goes without saying that this has not been recognized by the international community, including the UN, who considers East Jerusalem part of occupied Palestine, alongside the West Bank and the Gaza Strip. But in terms of what has been practically done to counter the unilateral annexation of Jerusalem in light of international law and in light of the repeated verbal condemnation of the UN and many others, unfortunately, there has been very little to show to date. But what I would like to reflect on, if you will allow me, is whether this unilateral annexation of Jerusalem through the 1980 Basic Law is a violation of that article that I referenced earlier in the presentation, the prohibition of conquest and annexation by force or threat of force. Now, I'm sure many of you will agree, and I hope all of you will agree, that the unilateral annexation by force after a period of occupation from 67 to 1980 is in fact conquest. It is in fact annexation by force. It is in fact a violation of Article 2.4 of the UN Charter. And this is something which unfortunately receives very little attention by, I am embarrassed to say, international lawyers, as well as many non-international lawyers. There's a lot that is said about the injustice in political and moral terms about what has happened in Jerusalem. But international law tells us clearly that this is unlawful. It's a violation of Article 2 of the UN Charter. Let us look a little bit further. Let's not just look at Jerusalem, but let's look at the occupation more broadly. The law of occupation is a very puzzling part of international law. Occupation is not technically illegal under international law. And indeed, a large chunk of international humanitarian law, IHL, the Fourth Geneva Convention in particular, is dedicated to regulating occupation. So the question is, how can it become illegal? Now, there's been quite a lot written about this by international law scholars. Now, of course, there can be repeated violations of international humanitarian law by the occupying power, which are illegal, within a framework of legal occupation. So what is the threshold? How many repeated violations of international humanitarian law must we see before saying, hang on a second, actually the entire framework has become unlawful? Examples, of course, of forced, plenty. The forced displacement of civilians is one that I focus on in my own research. There's a second thing that we should reflect on. An occupation can also become illegal, not just when the individual repeated violations occur and cement, but an occupation can also become illegal when it seeks to modify the reality on the ground. There are quite a few scholars who have written about this, including some Israeli legal scholars as well. So this is a second way that we can look at a transformative occupation and say, hang on a second, even if it is regulated under international law, we can say that now this has become categorically illegal because it seeks to modify the reality on the ground. We know through wherever you look really in occupied Palestine, we see examples of how the reality on the ground has changed since 1967. There's also something else. We're talking about 50 plus years of occupation. So the question is, has occupation become a cloak for annexation? I think the short answer that many international lawyers would agree with is yes. De facto, if not de jure, so by way of facts, as opposed to in the law, the occupation has, in a way, evolved in a way to suggest that large parts of Palestine have been occupied by Israel, which is problematic for political reasons. It's problematic for moral reasons, but it is also problematic for reasons of law. And again, I draw your attention to Article 2.4 of the UN Charter, which bans conquest through force used or threatened. And of course, a military occupation of 50 plus years is backed by military might. So the de facto annexation of East Jerusalem also through the Basic Law of 1980, and the de facto annexation, which hasn't been formalized by Israel in the same way, although for those of you who follow politics in the area, we know plenty about this being in the pipeline, is problematic and again is a fundamental violation of that principle contained in Article 2.4 of the UN Charter. So the question is, has occupation become conquest, colonialism, apartheid by a different name? I would say briefly that the answer is yes when we look at Palestine, but the international legal framework say that this should not be happening. Let us fast forward briefly to the gutting of Palestine. We've seen partition, we've seen occupation, and with Oslo, Palestine is carved up further. We're all familiar with the areas A, B, and C map. The effects of Oslo have been widely reported by international lawyers, as well as political scientists, cultural theorists, etc., etc. But just to draw your attention on a few, Oslo has entrenched Israeli control on the West Bank and Jerusalem. Oslo was meant to end after 5 years, and yet we're talking about 25 years later, and things haven't changed. Area C is still under the complete domination of the occupying power. This has resulted in the exploitation and unjust enrichment by Israel through Palestinian resources, water, agricultural land, and more. There have been further restrictions imposed unilaterally by Israel. So the movement of people and goods has become more complicated by the year. We've all been through checkpoints. We've seen it. The war is another high-profile example of the effects of Oslo. So again, you know, Oslo has contributed to the de facto annexation of Palestine by Israel. But remember the prohibition set out in Article 2.4 of the UN Charter. Territorial conquest by use of force or threat of force is banned. There is a clear prohibition. Let's fast forward. There's been much more that's gone on since Oslo, and I don't have time to look into much of it in any detail. Let me draw your attention to the Gaza siege, the settlement enterprise in the West Bank, and related Palestinian displacement that we'll touch upon in a moment, displacement and demolitions in the Jerusalem periphery, the right of return, for example, the recent Gaza march of return, and of course the further fragmentation of Palestine and separating Palestinians. Think about IDs, think about how births and deaths are regulated by the occupying power, dividing families. And there's much, much more that can be said that I won't have time to go into. Let's fast forward though to December 2016, when for the first time the US under Obama's last weeks decides to not get in the way of the Security Council resolution that finally reaffirms that the establishment by Israel of settlements in the territories occupied since '67 has no legal validity and is in fact a flagrant violation under international law, as well as being a major obstacle to the achievement of the two-state solution. Whatever we might think about this, this is the UN position, and of course a just and lasting and comprehensive peace. What this tells us is that the UN does not recognize any changes to the borders other than those agreed by the parties through negotiations. So international law has not changed its position despite, for example, what Trump might have tried to do or other actors. Let me move on to the issue of demolition and displacement in Bedouin communities. So 2016, clear UN statement through the Security Council, its executive body, that settlements are a violation of international law. That has not stopped, unfortunately. Dozens of Palestinian families living across Palestine from feeling the effects of the settlement enterprise that has not stopped despite the 2016 UN Security Council resolution. The Bedouin communities that I would draw your attention to have faced the sharp edge of this. In essence, the Bedouin displacement in the West Bank is driven by the settlement enterprise. So fewer Palestinians, including Bedouins, means more Israeli settlements. It's a simple game of more of one, less of the other. Continuing displacement is considered to be one of the key drivers of humanitarian vulnerability in Palestine, for all of Palestine. This is UN OCHA reporting, and I'm sure you're all familiar with some of these numbers. We're talking about not just displacement and demolition, but also relocation, and in some cases, forcible relocation to urban settings, even when the Bedouin communities may not wish to relocate to urban settings. It's important to recall that most of these Bedouin communities in the central West Bank are also registered refugees from 1948. These are some of the latest tragic images from UN OCHA reporting on demolitions and displacement in the West Bank. So far in 2020, 869 Palestinians have become homeless and more, and counting. There's an issue around the Israeli issued building permits, but of course, due to the discriminatory planning regime that Israel imposes on occupied Palestine in the West Bank, Palestinians can never really obtain such permits. Demolitions are also a key tool to create an environment which international lawyers refer to as a coercive environment that pushes Palestinian Bedouin communities and other Palestinian communities to facing extreme situations of vulnerability, in the hope that one day they might say, enough, I will leave of my own accord. But of course, it is not a choice to leave. If they do leave, it's because of the demolitions and displacement. I'll draw your attention to the tragedy of these pictures. Look, that's a picture of a bed with a child's cot next to it. Those of you who are parents, I'm sure, would see this and your heart would bleed. Even if you're not international lawyers, you know this is wrong. Well, fortunately, even international lawyers say that this is wrong. COVID has not slowed down the demolitions in the West Bank. We have a recent statement by OCHA that illustrates the concern and the fact that as little as 96 hours notice is given before demolitions occur. The E1 plan is an Israeli plan to expand Israeli control and Israeli settler communities in the Eastern Jerusalem neighborhoods. And this is an area of particular concern to Palestinians living in that area, many of whom are Bedouin families, to the state of Palestine and its institutions. And it's increasingly becoming a priority area also for the international community. The UN has got this on its radar as well. What does international law tell us about demolitions and displacement? We're talking about grave breaches of the Fourth Geneva Convention. Again, one of the two fundamental documents of international humanitarian law. The occupying power, Israel, is prohibited from destroying real and personal property unless it is absolutely necessary by military operations. You'll appreciate, just looking at the images from a couple of slides ago, that the absolute military necessity of demolishing whatever structure was providing a roof over the head of the people sleeping in that bed, of the child, the baby sleeping in that cot, does not stand up to scrutiny. Article 49 of the Fourth Geneva Convention prohibits individual or mass forcible transfer and deportations of protected persons, i.e. civilians, regardless of their motive. Let's also look at international criminal law, though. Both demolitions and displacement constitute a war crime. International human rights law as well is part of the framework that we need to be mindful of when looking at demolitions and displacement in Palestine, and in particular in the central West Bank. What part of human rights is not affected by demolitions or displacement? Think about children's rights. Think about the right to health. Think about the right to family life. Think about the most basic human needs which are protected in the international human rights law framework. All of them are affected by the demolitions and displacement. But there are also higher, quote unquote, order human rights, such as the range of civil and political rights. You know, how can you enjoy freedom of speech, for example, and carry on as, say, as a young blogger, if you have had your home destroyed, if your computer has been bulldozed. So my question to the audience is, can you think of some of these rights and offer some answers, maybe to the moderators in the chat? What sorts of human rights might be affected, violated by demolitions and displacement in Palestine? You'll be pleased to know, and we will all be pleased to see what this means, that even the ICC prosecutor has been keeping a close watch on what happens in Palestine. And that includes the destruction of property and forcible transfer of civilians in occupied Palestine. In particular, about a couple of years ago now, Fatou Bensouda issued a statement specifically about the Bedouin community at Al-Khan al-Ahmar. So this is on the radar as a potential war crime. This, I think, clarifies the gravity and scale of demolition and displacement in Palestinian communities in the West Bank, and the ICC prosecutor has appreciated this in her capacity. Of course, we haven't seen any progress to the Palestine case yet at the ICC. But it is included, the Bedouin displacement issue is included in the list of situations considered by the ICC. Her 2018 report talks of alleged war crimes in relation to the demolition and evictions of Bedouin communities in E1. So this is, I think, a very important opportunity for civil society and human rights activists, for you, for academics, people like me, and anyone who cares about justice for Palestine or justice for everyone, everywhere, to ensure that there is accurate and detailed information about this, to make sure that we shape public opinion and that we inform politicians and diplomats' actions, and make sure that the ICC is supported. The ICC operates within the UN family, but of course it is vulnerable to everything we know already in terms of political pressure, funding restrictions, which might be the reason why it's taking so long for the pretrial chamber to issue a decision on territorial jurisdiction on Palestine. And we'll touch upon this in a couple of slides. But as an aside, as Per-Anders already mentioned in his kind introduction, a few of us, including our project partners at Al-Quds University in Palestine, are researching how impunity for international law violations, repeated international law violations, exacerbates the humanitarian vulnerabilities of the Bedouin in E1. So there are many ways to inform the conversation. So I hope that many of you in Sweden will also be writing to your members of parliament and contributing through blogging or the other advocacy activities you're involved in. So in the final couple of slides, I'll touch upon the two pending Palestine cases at the ICJ and at the ICC. The ICJ was established with the UN Charter, so it's been around since 1945. Its aim is to settle disputes between states primarily. The ICC was set up in 1998, so it's a much younger institution, and it's not really interested in states. It's interested in international criminal responsibility for war crimes, crimes against humanity, the crime of aggression, etc. So slightly different bodies with different adjudicatory functions and focus. So the ICJ has actually already dealt with Palestine in its 2004 advisory opinion, which is not a contentious case, in which the UN General Assembly asked it to determine the legality or illegality of the wall, the wall is indeed illegal, but in the obiter, the ICJ confirmed, and this is important for all of us, confirmed that international law, including international human rights law and international humanitarian law, applies across the areas occupied in 1967. This means that Palestine is not a legal black hole of international law, and we must not treat it as an international legal black hole. We must make sure that international law extends throughout Palestine. There are current proceedings between Palestine and the US pending regarding the embassy transfer, but these are in their infancy, and things might change now that Trump's term is over. In terms of the ICC, however, about a year ago, the Office of the Prosecutor concluded her preliminary examination activities and requested a ruling on the territorial jurisdiction of Palestine. This includes everywhere: Gaza, West Bank, and East Jerusalem. There are possible directions that we could look at, and perhaps we can expand in the Q&A. Both these courts do have the potential to make a difference, and I'm happy to discuss further in the Q&A. Thank you very much.
Thank you so much, Alice, and thank you, Henrik, for sharing your knowledge with us.
So a very big thank you. This is Corona times, and if we were in the same hall, we would be, of course, handing out a flower bouquet to everyone involved, and I don't even have a virtual flower bouquet here. So, but anyway, we're very grateful. I've learned many things. I've studied this very much, but listening to Alice and also Henrik here, so many things that have fallen into place, and also we can also see all the good follow-up questions here. So a big thank you, and a thank you to my co-moderator Anna Wester. Yeah, something I have forgotten maybe, Anna. Is there something we need to say?
Thank you to Per Schitt also.
Oh, thank you. That's me.
And for everyone that was attending.
Yeah.
Thank you for a great evening.
Okay.
A very big thank you to Anna and Per and Henrik for inviting me.
Thank you, Alice. It was a pleasure.
Really a pleasure. Okay, so just have a look out on specifically, I would say, the social media sites of PGS, and there you will see when we will have ideas for the next upcoming webinars. Everything will be found there. So have a good evening, everyone, and hope to see you all soon again, as soon as possible. Thank you so much.
Thank you.
Bye-bye.
Bye.
Bye-bye.
Thank you.